You're watching the Law News Network, folks. We're covering the Morris brothers trial out of Phoenix, Arizona. That's a case involving two NBA players who are both on trial together, Marcus and Markieff Morris. They're accused of aggravated assault along with a third person over an attack on a victim named Eric Hood. Caroline Polisi is here with us on Law News. It's been a long time. I haven't seen you in a while.
I know, it's great to be back. Reunited, and it feels so good.
Well, that's good. I'm glad that you've come back. I haven't scared you away with anything that I've said about the Holly Bobo trial.
No, not at all. I love your coverage. I watch it in the afternoon.
Well, that's good. That's good. So we're talking about the Morris brothers case now, and you know, this testimony this afternoon is pretty serious because we kept hearing these insinuations that there was something going on between the victim and maybe a friend, and it sounded at first like they were joking about the thought of some eventual civil recovery for pointing the finger at these two NBA players who have deep pockets. But now we're hearing some insinuation that somebody may have asked this witness to lie about what he saw.
Exactly.
So that ratchets this up and makes it a lot more serious.
Right. I mean, I never believed it was a joke from, I mean, look, the story the defense is putting forth is that, you know, this incident occurred and the victim really saw an opportunity to cash in on the fact that he knew, look, we know the Morris brothers were there, so wouldn't this be a perfect opportunity to bring this to the bank? And I think the text messages that we saw from one of the witnesses on the stand about, you know, potentially cashing in on this too. I think she testified that she's saying that, well, that was just a joke. I don't think it was a joke. And I think here we just heard some testimony too from this witness that he apparently was approached as well, saying that he could cash in on this potential payday if he were to identify the Morris brothers as having partaken in this assault. So look, I've always felt that the fact that this case is even in trial means that I'm not so sure the Morris brothers did this, because if they really had done it, this is so clearly a case that you plea out, that you take a deal in, that you kind of sweep under the rug and you want to just get on and move over with it. That they're going to trial on the principle of the matter. I think that they feel like they were not involved and they want to clear their name.
Well, here's the thing I was talking about before. Whenever you have professional athletes involved in some kind of a criminal matter, the question isn't so much whether they did it or didn't do it. It isn't even so much, you know, a conviction as to the charges. It's a question as to whether or not they're going to be allowed to keep playing.
Right.
And certain criminal matters trigger certain provisions in professional sports contracts. And so I'm sitting here trying to say, okay, well, you know, my own homework assignment for the night is going to be to go back and figure out what layer of charge an aggravated assault is and what language in the NBA players agreement would be triggered by such a conviction. Because usually my experience is, and I've covered a number of these stories in a number of different cities, whenever a professional athlete gets in trouble, they get an attorney, and it's not so much about beating the criminal charge, it's about protecting their ability to play.
Absolutely.
Because if they can't play, they don't get paid, and you're talking about millions of dollars on the line.
Yep.
So this one's different. This one's different. Now, maybe it's that this evidence was coming out that all these other folks were talking about a payday. And even if the brothers were involved, they could, and again, this is hypothetical, maybe they're just like, well, we can beat it because we think that these accusers are slimier than whoever attacked them.
Right. Well, I'm very interested to hear from the two defendants that have already pleaded guilty to this crime and whether or not they're going to get on the stand to say in their words what happened. I think that's going to be a key piece of this puzzle. And I don't know if we've heard about witness lists yet. Do we know? Are they going to take the stand?
I have not heard yet. I'm certainly just as curious as you are.
Okay. Yeah, I mean, I agree. I'm not so into the sports situation that I understand all the intricacies of the sort of legal ramifications of, you know, sitting out, I think, 10 games they would have to there would be an automatic suspension of 10 games if they were to be convicted for a felony. Is that the rule?
I haven't looked into it, so you're telling me for the first time. I have a little bit more experience with NFL than NBA, but it's usually, I mean, it depends on the severity of the level of the charge.
Right. I mean, look, again, in my mind, we rarely cover assault trials on LawNewz Network because you just don't see that many of them. This was like a parking lot scuffle that took place, and the fact that we're devoting this amount of sort of time, resources, and energy to a 2-week trial, this goes beyond sort of just the mere fact of whether or not this incident took place. This is being litigated because these two defendants believe that they are innocent and they want to clear their name. And the prosecution clearly doesn't.
Well, maybe not. I mean, now, today this got way more serious to me because I took the text messages a little bit differently than you did.
Okay.
I mean, let's say hypothetically again that I walk out of here and some professional athlete punches me in the face.
Right.
If I text anybody that I know
Your lucky day.
happened, that's how they're going to respond back
Right.
to it. And so,
But
I don't know if
that really? I mean, so you think that anybody would go there? You would jump immediately?
I don't know if
that.
anybody, but there are enough people out there who would do it.
Mm-hmm.
Okay, especially people in this community, because again, it seems like the people who were involved in this knew the brothers.
Yes.
We've got the picture up of them from years before, like they knew one another.
Right.
They were in some kind of a community together. Everybody knew that they had money.
Right.
So all of it, if it happened the way that it's been alleged by the prosecution, then ergo, people are going to talk about where the money's going to start to fly around. Where it crosses the line, in my opinion, that's just been levied here, that somebody's has asked a witness to lie about it. That's where that's where I just turned around and said, okay, maybe this didn't happen the way the prosecution has alleged.
And I think the waters could be muddied a little bit in terms of, just to what extent the Morris brothers were in fact involved. We know that they were there. Obviously, we know that they left the scene of the crime all together in their car. So, and the testimony that we just heard from the most recent witness sort of has them sort of standing by the scene, maybe watching out a little bit. I think his testimony was that he got the impression from one of the Morris brothers that he wouldn't mind if he just walked away and stopped sort of witnessing this event taking place. So, the question is whether or not the victim perhaps has embellished now their role in the crime, or whether or not he's being truthful. So I think that could be an issue.
That's a big issue. Then it's a question of, okay, well, which brother
Yes.
has to walk away? Because if you can't prove which
Yes.
one it was, I mean, does one wind up with a conviction and one doesn't?
Exactly.
And then which one does and which one doesn't? So
And they do look so much alike. I mean, oftentimes
They're
you
twins.
see twins.
They're
I know,
twins.
but I'm saying oftentimes with adult twins, they don't necessarily always look that much alike, but in this case they really do. So,
and this isn't a case where one is, a scientist and the
Right.
other is an NBA player. They
Right.
both took similar careers.
Right.
I mean, so yeah, there are a lot of questions here. Let's listen to some of the earlier testimony in this case. So one of the friends of the victim who was attacked was, I think, the third witness called in this case. I want to listen to her describe the attack in chief, and we'll be back with more analysis in a bit.
All right, and what does the person that made those comments to Eric do next?
He says, "What's up, hood? You know what it is." And then he's standing there, and then someone darts in front of me, a short, dark-skinned guy, and he hits Eric. I'm on Eric's left-hand side. He hits Eric, like right in front of me in the back of his head.
All right, and did you get a good look at that individual?
Yes, I did.
All right. Did you see him running up to hit Eric the whole time?
Well, my focus was on the guy. We were both looking towards our right to the guy, what he was saying. So it kind of like blindsided me. He came so fast.
All right. And once he hits Eric, what happens next?
Eric immediately takes off running. He heads towards like the grass dirt area to where his car, I'm assuming he's running to his car. His car was backed in. Then he falls, he trips, and then that's when I notice another guy comes up. He's light-skinned, he has like a bandana on. He comes up, he starts kicking, punching him, and then I notice the other two boys, they're right behind him. They're hitting and punching him, which is the dark-skinned guy and the stocky, like light-skinned guy. And then that's when I noticed the twins as well.
All right, I'm going to stop you there, and we're going to try to break this down a little bit.
Okay.
So Eric gets hit, and then you said Eric runs.
Correct.
Where does he run to?
He runs towards the left, like his car is backed in on that first parking spot where like all the cars are. So it looks like he's running towards his car, but he trips, or I don't know if they tripped him or if he got tripped up, but he falls right there.
All right, so he falls in that area. Do you remember what is in that area?
In that area, it's like dirt, like grass, like brown grass area. It's like dirt almost.
Okay, so you watch him fall. Is there anyone else besides the people that are involved in this fight in that area?
No, there was not.
Do you see basketball players standing outside?
I didn't notice the basketball players until after.
All right. So when you were observing what's going on, the only people you see are these three individuals that are attacking Mr. Hood and then the Morris brothers.
Correct.
All right. And you said that the three individuals, well, I'll have you ask you again, when Mr. Hood falls, who's attacking him?
I noticed the light-skinned boy is attacking him, the dark-skinned boy is attacking him, the guy with the bandana is attacking him, and the twins are attacking him.
All right. So you see all five individuals attacking Eric.
Correct.
And how are they attacking Eric?
They're hitting and they're punching him and kicking him.
All right. So once you see this happen, what do you do?
I panic. I run back into the gym. I'm screaming, help, help. There's a referee, he's there, and then there's a white guy, he's there as well.
All right, so when you say you ran back into the gym, let's break that down a little bit too. What part of the gym do you go back into?
Okay, so the doors are still open. The first part of the doors, I run through that. I run through the second part of doors. There's like an office that they're almost like sitting in, they're conversating, and I'm screaming, help, help. Come outside, there's a fight, my friend is getting beat up, and they just automatically dart out with me.
All right, and who did you say was in that office-like room?
There was a referee in there, and also I'm assuming that he was a coach. I'm really not for sure, but there was a white guy that was in there too.
All right, was there anyone else?
I want to say it was 3 people that ran out, but I'm not for sure.
Okay, but you can only clearly remember 2 people.
I can only clearly remember 2, the referee, which was the black guy, and then the tall white guy.
All right. And I'm going to back up a little bit. When Eric's getting attacked in that area, and we're by the parking lot at this time, are we correct?
The grassy area is right behind the parking lot, yes.
Okay, so we're still closer to that parking lot?
Correct.
What is the lighting like in that area?
There's a light post that's right there. There's also like picnic tables. There's also like a concrete table. So there's like lighting right there as well.
All right, so is it lit well enough for you to see what's going on?
Yes, it is.
All right, and is it lit well enough for you to see some vehicles in the parking lot?
Yes, it is.
All right.
That's Sharika Sharad, who is a friend of the victim who was attacked in this case. Caroline, when we listen to it out of this witness who is a friend of the victim, it sounds pretty simple. They leave the gym, the victim, Eric Hood, gets attacked, she runs in for help, then witnesses some of the rest of it and points the finger at the 2 NBA players along with some of the other people who were alleged to have been a part of this. But now we're hearing it might not be quite so simple.
Well, yeah, sounds simple enough, but I was watching Heather's coverage of the trial earlier, and she pointed out that her text messages here are devastating as well. I think she made the point that she could get money for sort of intentional infliction of emotional distress, which is a pretty well-researched legal theory, legal argument. So
yeah, and that's I don't know if it's really going to work.
Right.
Because,
Right,
in order
exactly.
to get an IIED claim, you usually have to be directly
Or maybe it
related
was just
to
emotional
someone.
distress. Maybe it wasn't intentional infliction. Probably
Yeah, but
just
even
emotional
then, you
distress.
usually
I know.
have to be directly related to the person who's being attacked, not friends with the person.
But I'm saying that, she clearly, maybe there's more to this story here than just that she was a hapless witness to the crime. So we'll get to the bottom of this, I think, for sure, throughout the trial.
Yeah, I think we've got a screenshot of the text messages that came up in court on Thursday. Again, that's the last day before today that this court was in session. They were in session Thursday of last week. They had Friday off, and they're back for the first time today. But the text messages back and forth with a friend back somewhere on the East Coast here. It may have been Philadelphia or something like that, where she's, basically saying, "Oh yeah, I'm going to be in some money because I witnessed this attack." Well, I mean,
but that also
see,
begs the
I
question.
took it initially as off color and inappropriate, but not
Right.
necessarily damaging to the case. Now I'm starting to think that this prosecutor's case has got some damage.
Yeah, I mean, it also begs the question, what she's referring to there is obviously a civil case, but the question is whether or not she may get a payout from the victim in this case for her testimony. I mean, you can take it multiple ways. You can take it sort of down the rabbit hole of multiple ways that she could potentially get a payday. And if the victim is sort of paying somebody for testimony, then that's very bad.
Well, let's dial back even a little bit further here and explain to people about the nexus between the criminal and the civil cases here, because we've got a criminal case, it's aggravated assault, so the state comes in and prosecutes it. But going on behind the scenes is this civil case where the victim is either suing or threatening to sue the people that he claims attacked him. And the way this usually goes out is usually civil litigants wait for the state to basically shoulder the cost of the criminal case. And if there is a conviction, it makes the civil case a foregone conclusion, more or less, because the criminal standard is
much higher.
Is a higher standard than the civil standard.
So the civil standard is a preponderance of the evidence. As we all know, we don't cover civil trials here, so we're always talking about beyond a reasonable doubt here at LawNewz. But yes, you're absolutely right. A civil case, much easier to win. You often see wrongful death suits in the wake of criminal prosecutions for homicide, murder, things of that nature. I think the O.J. Simpson case would be a great example of that, not convicted in the criminal trial, but then, of course, convicted in the civil suit. So because it was a much lower burden of proof there.
But if there is a conviction here, it makes this civil case for this particular victim absolutely a simple, easy thing to get. Usually it just winds up being a rubber stamp, more or less.
Right.
So the insinuation here is that if they're lying at the criminal trial, it will help the civil case.
Yes, I mean, if it would help the civil case if their lies are, believed.
Bear fruit, yes.
Yes, exactly. But if they're not, it's obviously disastrous for that case.
Well, yeah. So let's listen to a little bit more of this witness's testimony on Thursday. If we get to the point where she starts talking about these text messages, where she starts insinuating she might be in some money for being a witness to the altercation that she claims happened the way she claims it happened, we might get there, we might not, because court is probably going to be back into session soon. As soon as they're back live, we'll take you to the courtroom.
So you ran inside, you went into the office, and you're asking for help. What happens next?
As we come back outside, the altercation has, looks like, I don't know if he's getting up or he's running, but it's moving down a little bit. There is, I'm not for sure what twin it was, but the referee took off. The white guy gets stopped by one of the twins, and he puts his hands up almost to say like stop, you can't come down this far. And the referee's like, dude, you got to get out of here, you guys cannot be doing this, not on this property, you have to leave, like get out, everybody has to go. And he's very persistent that the guy cannot come any further.
Where are you at when this is happening?
We're in the street. There's like a long driveway, per se.
All right. And we're not going to look at it quite yet, but you actually were interviewed by Detective Santos a few times, correct?
Correct.
One of the times that your interview was later the night of January 24th, 2015 at a hospital.
Correct.
And you also did an interview with Detective Santos where you were presented some maps of the area.
Correct.
And did you draw on those maps and show where various things occurred based on what you saw?
Yes, I did.
Okay. All right, so you said at this point the fight has kind of moved down to the street area. Is that what you said?
Correct.
And what are you seeing in that area?
In that area, I lose sight. Like I said, one of the twins had stopped us. So by that time, the fight had moved down a little bit. I had lost sight of Eric, and he was very persistent that we could not come down there at that moment.
I'm going to jump to another question here. You said that there was the individual with the bandana.
Correct.
Do you remember where the bandana was on his face?
Yes, I do. It was wrapped like this.
Did you ever see that bandana on any other part of his body?
No, I did not.
And just so the record's clear, you signaled across your mouth?
Yes, like this. Yes, correct.
Across your mouth is a fair representation.
Across his mouth. Sorry.
You may continue.
Thank you. Do you remember what that bandana looked like?
It was like an army bandana.
Okay. When you say it's like an army bandana, do you mean a fatigue pattern?
Yes, correct.
Okay. And you are actually, later on, are able to identify that individual in a lineup.
Correct.
So the obvious question is, how are you able to ID that individual when he has a bandana around his mouth?
I could tell by his eyes and his ears.
All right. So you noted particular parts of his body that stood out to you. And also continue with him into where we are. Did you see that individual run down to the street area?
Correct.
All right. So now working our way back down to that street, what do you see going on?
Then that's when I guess that was the coach, the white guy, he had ran past the brother. They were running. I was kind of hesitant, so I was walking very slowly.
Okay, I'm going to stop you there. I'm sorry. When you say you're a little way, are you a little ways away from them?
Yeah, a little ways away from them, correct.
All right. Why are you not running all the way down there?
Because he's seen my face, and I was standing next to the actual coach, so I didn't know if he would maybe try to do something to me, so I kind of let them go in front of me.
So were you scared to get involved in that situation?
I didn't want to get hit.
All right, so you said you're running down there, you're a little bit behind the coach and this other, did you say Morris brother?
Correct.
And what happens next?
Like I said, I lost sight of Eric. I didn't see him anymore. And then I noticed that they were all coming back, because that street is pretty long to walk down. So I noticed they were all coming back. That's when one of me and the twins had words. And then he's like...
I'm going to stop you there, and we'll get to that in a moment. But when you say you didn't see Eric anymore, did you see him being assaulted down by the street?
No, I did not see him down there being assaulted.
All right. And did you see anyone else in that area assaulting him or kicking him or anything of that nature?
I lost sight after that point.
Okay. And how is the lighting down at the end of that street?
It's very dark.
All right. So that's dark. You don't, and you actually are standing behind the coach that you said, the white coach.
Correct.
Okay. And then you said you start walking back. Where are you walking back to?
Heading towards like my car. They were all heading back towards where the cars were parked at.
All right. I'm going to ask you to just further describe what you mean when you say they.
Okay, I'm sorry. So the individuals that I had described, the light-skinned guy, the guy with the bandana, the dark-skinned guy, and then the twins were walking back towards the cars.
All right. And we didn't talk about it because maybe you had not observed it yet, but did you see a fancy car in the parking lot?
Yes,
I'm sorry, go ahead.
yes, I did.
And what type of car did you believe that to be?
At first, I didn't know if it was a Rolls Royce Phantom, if they're considered the same things, but it was a very nice car.
All right, and when you say a Rolls Royce Phantom, are you familiar with that type of car?
Not really. I've seen it a couple times on TV, but like I said, I didn't know if it was the Rolls Royce or it was I don't know if those two coincide together.
Okay. When did you first see that car?
Not until they were walking back. It was almost like the car was lit up.
So you did not see the car when the initial fight was occurring?
No, I wasn't paying attention to cars at that time.
Okay. So you're walking back at this point with the individuals that you already stated, and you start to have a discussion with one of the twins.
Correct.
To be fair, can you tell the twins apart?
No, I cannot.
So if you were to look at the twins here right now, you don't know who's who.
No, I don't.
All right. But you're walking back and you know you're having a discussion with one of them.
Correct.
And what's going on in that discussion? What's being said?
I said, I can't believe y'all just did that to him. And he said, Shawty, you don't even know him like that. And then I said, yeah, but it's still wrong. And I said, and you don't know me. And then he goes, no, I said, excuse me. He said, Shawty, you don't even know him like that. And then I was like, well, you don't know me, that's still wrong. And then he's like, well, I'm from Philly. And I'm like, okay, and I'm from DC, so what are you saying? And then that was the end of the exchange.
Okay. So how long does that brief conversation last for? About as long as it took you to say it?
Yeah.
All right. And where are you walking to?
I'm heading back towards my car. So there, like I said, my car was in the second row. Their car was in the first row.
All right. And while this is going on, do you know where Eric is?
No, I lost sight of Eric at that point.
Did you know that Eric was down in that area still?
I assumed that's why I got in my car and I drove down that way, because they were coming back from that way when they got into their cars.
All right. And I failed to ask you this, but do you see Hispanic people in that area down in that area?
I don't notice them until I get in my car and drive down that area.
Okay.
We're still outside.
So I'm ahead.
Yes.
All right. And I didn't say this to you in the beginning, but the warning is attorneys ask bad questions sometimes. We think we do this a lot, so we think we ask good questions. But if I ask a bad question or something that confuses you, make sure you let me know, okay?
Okay.
All right, so you're walking back, you're headed to your car. Why are you going to your car?
They were leaving, and so I wanted to stay back and just watch to see what was going on before I pulled off. Like, I didn't want them to follow me.
Okay. At this point, do you see basketball players around the gym area?
Yes, I do.
What do you see?
I see that their phantom doors or their car doors are open. It's very lit up. There are kids standing around them and asking for pictures, like, oh, why you guys are still here? Can we take a picture with you? And they're just like laughing and joking.
All right. And this is by the vehicle that you believed is a Phantom.
Correct.
Phantom vehicle. Who do you see get in that vehicle?
I see the dark-skinned guy. He's walking up. He's holding his chest. He's like breathing really heavy. He gets in the back. Like I said, I don't know the twins apart. I don't know which one hopped in the driver's side. But I can see him like standing up front while the doors open towards like the driver's side. And the kids are like around the back of it, like snapping photos and taking pictures.
All right, and you said you stayed back and waited for them to leave.
Correct.
Did they leave?
Yes, they did leave.
All right, and once they left, did you see any other cars leave with them?
I seen an SUV that was kind of parked next to their Phantom. A lot of people were pulling out at that same time after the fight was over, but I did notice like an SUV.
All right.
The dark color.
And you said you saw 3 individuals that were down towards that street get into the Phantom. Is that correct?
Correct.
Did you notice what happened to the other 2 individuals?
They kind of moved, so they were moving so fast. I was focused because, like I said, their car was lit up. It has a lot of lights. So they could have walked in front of their car and got in another car, but they did not get in that Phantom, no.
So were you more focused on the Phantom?
Correct.
And you weren't really paying attention to the other two individuals?
Correct. I did not pay, but I know that they did not get in that car.
And you said there was an SUV that left about the same time?
Correct.
But to be fair, you don't know if that SUV was with
Don't
the
know.
Phantom or not.
You have to wait for him to complete his question before you begin speaking. Could you please restate your question that said, to be fair, you don't know?
To be fair, you don't know if that SUV was with the Phantom.
Correct.
All right. Okay, the Phantom is gone. Are you in your car?
Once they pull off, I do get in my car. I drive around. Like I said, there's a long driveway. I put my high beams on because heading down towards there, it's very dark. So I'm looking. I finally get to the end of the driveway. I notice the coach and the referee are still down there. They're standing around. I put my car in the park. I'm still sitting in my car at this time. I have my windows down, and I'm looking, and I see Eric, and he's like lumped over by the gate, by that grass area.
All right. And have you parked your car there?
My car's parked, yes.
Who else do you see in that area?
I also see there's like some Mexican people. They were boxing or doing something there at that like gazebo.
So there's a structure down there. Is it safe to
The
say there's a
structure.
structure down there by the street?
Yes, it is.
Okay. You folks have to be careful not to talk over one another, please.
There's a structure down by the street.
Correct.
And you see two Hispanic people. Are they at that structure?
Correct.
All right. Who else do you see?
I see the coach. I see the referee. There's a lady. Not for sure who that lady is. There's people still right there standing.
All right. And you said Eric looked hunched over?
Eric was laid down on the ground. He was slumped over.
All right. And what do you do once you see that?
I'm like, Eric, come on, get up, get up. I'm saying, get up. He's like he's non-responsive, like almost like he's out of it, like dazed or unconscious. The coaches are saying, come on, man, get up, get up. He attempts to try to stand up. The coach is like, open your back door. We're gonna slide him, because he's very tall, we're gonna slide him on your back seat. As Eric's trying to stand up and walk, he immediately like falls over. Like his whole body is limp. He just falls and hits the ground. And I'm like, oh my God. Like at that point, I really thought that he was dead. I've never seen anybody stand up and fall like that.
All right. Well, what happens next?
And then the coach, they're like, come on, man, come on. They're trying to help him up off the ground. They're doing all the work. They're lifting him up and they're putting him into my back seat.
And does Eric get into your back seat?
It was hard, but they finally got him in.
What?
So that was testimony from last week in the Morris Brothers case out of Phoenix that we've been covering, but we're going to switch gears again and talk a little bit about the Holly Bobo case, which wrapped up over the weekend. Caroline, we know that it resulted in a verdict across the board for the state, guilty on every single one of the counts. He could have faced the death penalty, Zach Adams, the defendant, but ultimately he sort of copped a plea right at the last minute as he was going into the penalty phase, and it resulted in a punishment of life plus 50 years.
Right.
So this is the first time we've had a chance to talk about it. I'd start with your core reaction to that.
Well, I predicted that we would get a very quick verdict in this case, and that came true. I did not see the jury having any problems convicting Zach Adams here. I know you, Aaron, had a lot of sort of misgivings about the procedural issues within the trial. I agree with you. I mean, there was hearsay within hearsay all over the place, but and perhaps, you know, I always say, look, I'm a defense attorney. I'm typically pro-defense, but this was one case that, of all the cases that we've covered here on LawNewz, that I really felt like I would have voted to as a guilty verdict here. I really would have, and I think that we talk also a lot about death penalty cases here at LawNewz, and we've talked about it being reserved for the worst of the worst crimes, and I think this is a clear candidate for the death penalty, and I think the defense made a really wise move in taking. Not only do they understand that the alacrity with which this trial, with this jury chose to bring back a verdict of guilty, they were likely going to vote to give him the death penalty as well. So I think they saved everybody some time, saved everybody, sort of the agony of going through the penalty portion in a death penalty trial, and took the plea, if you will. Obviously, they didn't take a guilty plea, but they took a plea on the sentencing
Well, yeah,
portion.
once they figured that it was a conviction across the board,
Exactly.
at that point the jury wasn't willing to slice and dice and say, well, if we believe that he shot her, but we're not sure if we believe the hearsay about the rape, that
Right.
jury didn't go into that level of detail, or if they did, they resolved it and just said, well, we're going to buy the state's case hook, line, and sinker. So as to what you would have voted had you been on the jury, are you voting based on the evidence that you did hear at trial or the evidence that you should have heard at trial?
Well, you can't unhear evidence. So I don't know what my vote would have been had all of this hearsay evidence that actually was allowed in, had that actually been excluded for proper reasons. So again, you can't unring that bell. I agree. It was just comical. It got comical at some points when the defense and the judge were sort of arguing back and forth about, in open court in front of the jury about some of the arguments, the legal sort of arguments, which are never supposed to be taking place in front of the jurors because it's so highly prejudicial. But nonetheless, it happened based on the information that I received throughout the course of the trial. I felt like this guy was involved. I really actually believed Jason Autry's testimony. I credited him. I felt like he was telling me the truth. I know that some people were very turned off or creeped out really by
Well,
the upfront nature he was. Yeah.
This defendant is not a sympathetic defendant in any way.
Not at all.
Look, if I'm to believe that it went down even half of the way Jason Autry said it went down, then it's disgusting. The guy's a slime bag. He's not a sympathetic guy. But see, maybe I was brainwashed by going to law school, because here's the thing. Sitting and watching the case, I would just look and say, oh yeah, that's the way it went down. That's disgusting. Lock him up. Do whatever the jury wants to do with him. But again, maybe I was brainwashed by going to law school, because when I see procedural things that go wrong, I then slam the brakes on my own thought process and say, now wait a minute, I'm inclined to believe it, but I don't know if I can trust what I'm hearing, because
Right.
I'm not sure if I agree that evidence should have came into the case.
Well, good for you. That's an
I
impressive
think-
level of self-restraint that not every
think-
human being can do. I felt so personally, this case touched me so personally. I just, maybe as a woman growing up, women everywhere are fearful of this exact crime. So something about it, I felt I connected with it on an emotional level. I really, I also thought that this case could be a rife case for sort of runaway juror nullification. Perhaps, even if the jury felt like the evidence for every single element that the state charged wasn't there, there's so much testimony that, look, this guy probably was there or did something that they may have just wanted to get retribution and find him guilty, even if they felt like in their hearts they weren't 100% sure, or there was a reasonable doubt as to certain elements of this crime. This case, of any other case, I felt like is the prime candidate for sort of the nullification aspect that a jury, because look, behind closed doors, we don't know what happens back there. We still haven't heard from many of the jurors. We don't really know what took place. You're giving me a weird
Well,
look.
I'm just trying to figure out how would you, I mean, a jury would nullify a case if the jury didn't think the prosecutor should have even brought the charge.
I know we have a different opinion about what jury nullification means.
Well,
And
at least that's where
use
it is in the state where I come
okay,
from.
what I mean is anytime a jury sort of takes the law into their own hands and refuses to, so the usual typical case is when they choose not to convict a defendant who's clearly guilty of a crime of murder because there's some moral, because they feel some moral kinship with the,
Yeah, I mean,
the
look,
defendant.
the classic case of it that I remember
Yes.
from New Hampshire that everybody talks about up there was the police decided to go arrest an elderly gentleman who they thought was smoking pot, and the jury nullified the case and just said, seriously, guys,
Yeah.
there are way bigger issues to go after than an old hippie who, you know, is reliving Woodstock or whatever happened.
Right.
Go find something that, you know, where there is more of a victim to the crime.
And it's a
or
runaway
something.
jury because they're not taking the instructions seriously. They're not supposed to, you know, obviously they're not supposed to take into account sort of the sentencing. They're just supposed to decide purely not the law but the facts of whether or not this crime took place. So I'm using it in sort of the flip side, saying that it may be that these jurors feel that Zach Adams is just a bad dude, that he just, you know, something's wrong there with him, and, you know, maybe he doesn't meet every element of, maybe they're not 100% sure about whether Jason Autry's story was sort of, you know, airtight, but they're going to go ahead and choose to convict him nonetheless because they feel like this guy should be behind bars.
Well, and you're making my point for me as to why the procedural rules about what evidence gets in and what doesn't
Yeah.
is important, because early on in this case, it was blurted out that the defendant had other criminal issues in his past.
Right.
Now, why that in and of itself wasn't a mistrial just right there, I don't know. But, you know, you can't unring that bell. And then there were other things, you know, time in and time out,
Right.
where I just had to look and say, okay, well, how does his past what does that have to do with whether or not he committed this crime? You know,
Right.
that's a double jeopardy issue in the
prior
Constitution.
bad acts, we call it, right?
Yeah, prior bad
Usually
acts,
not-
but it
not
also
allowed.
for those who are trying to say, well, how is it constitutional? Well, you know, it raises issues with double jeopardy. The Constitution says you can't be tried for the same thing twice. So if they're trying to bring your old crimes into a new trial, then, you know, politically we decided a long time ago that can't happen.
But it's more than just that. I think that it raises more questions than just double jeopardy. It's highly prejudicial. You run the risk of the jury simply saying, well, this guy's a bad guy. He did it then. He must have done it now. And so there's a huge risk inherent in bringing any prior bad act into the courtroom. I think, you know, the way we as defense attorneys or other prosecutors try to get around it is they say, you know, there's a theory if you say it's their MO, their modus operandi, if you can show that they did it, you can bring that prior sort of bad act in to show that there was a specific way that this guy commits crimes. Oftentimes it'll come in for that purpose. Like if a guy
Yeah, that's
killed
more
his wife.
impeachment than
Yeah.
it is,
Well-
which is why he didn't take the stand. But it's sort of like, you know, it already was in front of the jury at that point. So
Right. I think you should have taken the stand. I mean, I know it's highly controversial, sort of, you know, the sort of defense attorney 101 says never put your client on the stand. But, and I agree, look, there's so many impeachment issues and opening the door
here, look,
so
I
much.
mean, let's talk about the rules of professional conduct as well. I mean, you know, in different states handle this in different ways. But what's he going to say if he's up on the stand?
Well, I mean, what do you mean? What's he going to say? He's going to
Well,
say
what's
he
he
didn't do
going
it.
to say? I mean,
He's going to say he didn't do
so
it.
if he says that, and the defense attorney has some evidence that he did do it, then the defense attorney has to withdraw from the representation or refuse to participate in the questioning, depending on the state. So
No,
part of me is,
not if the defense attorney has evidence. It's if the defense attorney knows beyond a shadow of a doubt. So I mean, look, the defense attorney has the evidence that the state has, and the defense attorney is still moving forward with the defense of that defendant. So I don't think there would be an ethical obligation on the part.
At some point, though, if and again, I'm getting into hypotheticals. What if this defendant had said to the defense attorney, "Well, you know, yeah, I was involved."
Oh, okay. So yes.
Okay.
That's bad.
And I could see that happening in this case. I mean,
Really?
It's been a bizarre enough case. Why not? We'll throw another absurdity. And again, I'm just speculating here, just to point out the issues of the law. You know.
Yeah. I mean, she didn't. Yeah. The defense attorney perhaps she was operating under that assumption. Maybe she was operating under that assumption as well.
Or maybe she, look, I mean, I don't know what was said between the attorney and the client, but the rule is, and I've pointed this out before here on LawNewz, that if you come across some information that your client's going to lie on the stand, what happens if he gets up there on cross-examination, he says, oh no, I didn't do it, then she's got to withdraw, then what kind of a mess are we in there?
Yeah, big mess, big mess.
So, I mean, I think that to try to avoid that mess, he just didn't testify.
I think that's a big assumption to make. So you're making the assumption that he disclosed to his attorney that he is taking this case to trial.
Or that he wouldn't have been able to wiggle out of it on cross-examination somehow.
Well, but look, the idea is that you have the universe of evidence that that you presumably, before you put your client on the stand, you're sort of well aware of whatever impeachment evidence might be thrown his way. So if, beyond that, I think there could be an issue. If she has other information beyond the scope of whatever discovery, inculpatory or exculpatory discovery she has at her disposal, yes, that's an issue. But just based on the universe of discovery that we've seen presented in this case, and likely that I would assume there would be some back and forth between the prosecution and the defense. The prosecution sort of letting the defense know, hey, if you put him up there, we have this on him. So you're all sort of working with the same information. It's not like there are going to be any surprises in terms of impeachment evidence on the stand.
No, I agree with that.
Okay.
I'm just saying, there are a couple different scenarios
Yes,
here, and I know that mine is probably the least likely of the biggies. The biggies would be that he doesn't want the previous criminal record coming out on the stand, because once he gets up and testifies, they can impeach him on it.
Right.
So, well, then again, it came out in other parts of the trial anyway.
Right.
So,
I wonder
I don't know.
I wonder, hindsight is 20/20. I wonder if the defense, knowing what they know now and knowing how the jury voted, whether or not they would have sort of taken that risk and put him on the stand. Because the fact is, regardless of anybody's Fifth Amendment right, jurors want to hear from the defendant. And, you can instruct them time after time that you can't draw a negative inference from the fact that the defendant does not take the stand. But human nature tells us otherwise. So, there is this desire on the part of juries to actually hear from the defendant's mouth, I did not do this crime, I did not commit this crime. And it's simplistic, but you think, if you were being accused of something that you didn't commit, why would you not get on the stand and assert that? So it can be a very powerful tool.
well, it's hard for juries to go into the box and say, this is all about the state proving its case beyond a reasonable doubt. The burden is on the state. Wasn't there a public opinion poll a number of years ago that said the vast majority of Americans thought that the defendant had to prove his innocence or something like that?
That's scary. That's scary if that's true.
Well, but you've got cases like this where there's nary a word said, if anything. If it was said, it was negligible about burden of proof in this case.
Right.
We didn't hear a lot of hammering on that. We saw the defense basically trying to prove somebody else may have been involved.
Right.
That could have been a part of the defense, but to me, the big defense is burden of proof.
She should have taken a page out of Jose Baez's playbook and put the old thermometer up there. That's a classic, the thermometer of reasonable doubt. And where do you get to the reasonable doubt? Because to illustrate in a very sort of hands-on, tactile way to a jury, just how far you have to be positive that this person perpetrated the crime, and what little amount of doubt there can be in order for you to vote for an acquittal.
Yeah, let's. I want to listen to some of what the defense had to say after this proceeding wrapped up on Saturday. This was a news conference that the defense attorney had with reporters at the conclusion of the proceeding. I have not heard this yet. I'm very curious to see exactly what she said and where she thinks the case may go from here.
Never linked Zach Adams to Holly Bobo. There, and there's some evidence that didn't come in at trial. They seized all his cars. They went through his house with a fine-tooth comb. They went over everything, and there's absolutely no evidence. The story that Jason Autry told really doesn't make sense. I'm afraid the fact that Zach Adams went around high and was saying a lot of inappropriate stuff before he was arrested you know, that some of that stuff is just stuff you can't get past, and I'm afraid that the jury took a lot of those comments to heart. And just the other thing I'm concerned about is we put on a lot of evidence about possibly Terry Britt being involved, but we don't have to prove that Terry Britt did it. You know, the whole idea was to raise reasonable doubt. My concern would be that maybe the jury misunderstood, and if we didn't prove that Terry Britt did it beyond a reasonable doubt, that then they are thinking that perhaps that means that Zach did do it. You know, that was one, that they then had to pick one or the other. And that's certainly not what we could ever possibly hope to do, because we don't have the resources to prosecute somebody. So that's my other concern.
Did Zach Adams say anything to you after that?
You know, we discussed it before the jury came out, and based on the questions, I thought it maybe didn't look good, and I told him I thought it was going to be a guilty verdict before the jury came out, and that we needed to plan for a guilty verdict. My expectation was that he was going to sit there and be very stoic, because I reminded him this jury's going to decide tomorrow whether he lives or dies, and that it was really important that he be quiet and respectful. And he took it like a champ. I could tell he was trembling, and he went white, so I could tell he was very upset. I think he's really surprised, but I think he took it like a champ, sitting there, and gave the reaction I'd hoped for him.
What's the next step here now?
Well, you know, tomorrow we start with a whole sentencing portion of it, whether or not he's going to be executed, and I have to say I'm very concerned. You know, I know, again, I'm really worried that in a case like this, because of the stark contrast between kind of the two players, Holly Bobo and Zach Adams, I'm concerned that the jury might go for death. And, you know, for me, who sees Zach Adams as being an innocent man who's been convicted, the fact that he could get death penalty is just, it's really frightening to me.
Do you still have concerns about an unbiased jury coming out of Hartford County?
You know, I think that we were not able to go through and really ask the jury the questions we wanted to ask them. Everybody said that they had heard about the case. I think everybody on the jury had heard something about the case, and I just think that it's so close to home, just one county over, they'd heard so much. I'm not sure that you can get an unbiased jury when they've heard, you know, a lot of people had heard about Shane Austin's suicide, and I don't think that should have come in at all, about Shane's suicide, but it did. The state put it in first, and I think just things like that go to bias everything, and so it's a concern.
What do you think the key factor was that made this jury decide what they did?
Gosh, if I'd known, I would have prepared more for it. I really think that a lot of people believe that if you say something, then it must be true. And I think that, you know, when you have people coming in and jailhouse snitches coming in, I tried to argue that, you know, the jailhouse snitches would have been able to hear what he said on the phone. You know, he's got no privacy in there. They can hear everything that goes on, and that they could, all they have to do is do a few comments, you know, repeat a little bit of what they've heard Zach say about the case, a few facts, and then add on the end, and then he confessed to me. So that's a concern of mine.
Do you understand that with 10 different voices from 10 different places, from in-county, from out of state, that had a powerful aggregate effect?
Oh, I understand that, and we knew that going in. The problem is that there's also the $250,000 reward. You know, Jamie Darnell admitted that he was told that they'll decide after people testify as to how they're going to divide up that money. And I think especially if you're talking about a drug crowd and a criminal crowd, that money means something to them.
Did it come down to a situation where the jury believed Jason Autry, in your opinion?
Gosh, I think they would have had to. I don't know how much they believed him, or if what he said combined with some of the words they put in Zach Adams' mouth did the conviction, but I know they didn't convict based on evidence, on physical evidence. because there's no physical evidence. So it had to have been what people said.
What about the schism in the TBI? There's two different, this bifurcated path. Were you hoping that would make a big difference? Because you spent a lot of time on it.
Well, I was hoping that, I've never before called 5 law enforcement people to testify on my behalf, and I've been doing criminal defense 20 plus years. So, did you have a question?
My question was, what was it? Something, sorry, I lost it.
Oh, I don't know. I'm not sure.
Talking about the testimony from Jason Autry, I mean, how did you prepare for that in your closing arguments?
The testimony from Jason, well, I tried to just pick it apart. The problem is Jason's story was based on some truth. They were clearly over there by the river that day. And by using some little piece of truth on that, he's able to weave a story. But I just thought, that's not the place you'd go to dispose of a body. You wouldn't go to the river where everybody is fishing. They live out in the country. You just go way out in the country somewhere. I thought his whole story, it didn't quite fit with his phone. My suspicion is that the jury at some point decided that that maybe the 2 other people that weren't on trial, that Dylan or Shane Austin had something to do with it, because I think the evidence also kind of clearly showed that Zach's phone was not with Holly's phone. And if you're going to believe Jason's story, Zach had his phone. So they had to have somehow, and there was even less evidence about Shane Austin and Dylan Adams, but they had to have just made that leap.
Talking about some of the missteps by the TBI that were brought up in this case, do you think that would maybe help you, help Zach Adams in this case?
Did I think it was going to help them? Well, I don't think that just because the TBI made some missteps in this case was enough for the jury to decide that Zach Adams is not guilty. I don't think that. I do think, Brent Booth got up and testified that there wasn't any pressure to solve this case, and Mark Gwynn is here today. I think there was pressure to solve this case on the TBI, and I think they had to find somebody to charge.
You did object when Brent Booth was on the stand at the end saying that, he had the right man. What are your thoughts on that?
Well, he didn't have the right man. He did not have the right man. I mean, we still maintain that Zach Adams is innocent.
How does someone on the TBI state that, though? Would that
well,
change the jury's...
The thing that really frustrated me about that is the state had filed a motion in limine to keep Terry Dykes from saying on the stand that he thought Zach Adams was innocent, and yet they worked in through Brent Booth to say that Zach Adams was guilty. That frustrated me, that the prosecution had done that.
Why was there never a push? You never really mentioned an alternative theory as to where Zach was when this happened, or an alibi. We heard the working theory was it wasn't him, but
right. But that's the thing. That's the thing, and that's, when you go back and look at some of these cases that are overturned years later after wrongful convictions, it's so hard to come up with an alibi when you didn't know you needed one on that day. The person that had the crystal clear alibi, even though it turned out to be a lie, was Terry Britt. Zach didn't know he needed an alibi, and he didn't have a good alibi for that day. And that's part of the problem, is that if you didn't know you needed to be with someone and you didn't know you needed to be recording it and making a record of it, you don't.
There was a lot of kind of during you laying out your proof in your case, kind of all over the place. Is that kind of to mimic your thoughts on how the investigation was, kind of all over the place?
Well, the investigation, it was really thorough, but I think that there were still so many questions that were unanswered. Even if you look at the way the state did their case and the state did their proof, their questions have not been answered. Who took Holly? Who was there that morning? Who took Holly? What car did they drive? Because Shane Austin didn't have a car. If you believe Jason Autry's story, when he leaves the house, there's not an extra car there for them to take. So did they really go by the corn crib and rape Holly for just a few minutes? If you look at the phone experts, her phone passed by there very quickly. Her phone passed by that area within about 10 minutes. So that would have been a very short time for 3 people to have raped her. I think it just cannot be accurate the way that the state's the state's theory could not have been correct.
Are you already thinking about an appeal, and what will that look like?
Well, of course we're thinking about an appeal, and I think that'll be long and slow. You know, appeal processes are never quick. I think that there's some mistakes about evidence that came in. Some of the evidence that came in I don't think should have. The state was able to get in some hearsay, which they claimed was not for the truth, but the whole thing about the rape taking place in the corn crib was hearsay, and it shouldn't have come in. You know, things that Dylan Adams said or Shane Austin said should not have come in. I think the state waved around that little piece of paper like it was some kind of confession from Shane Austin, and it wasn't. It was not about Shane Austin, and they also put in that Shane had an immunity agreement, which I think shouldn't have come in.
Is there ever discussion of having Zach Adams, take the stand and give his account of what happened?
You know, Zach, there was, and Zach very much wanted to tell his story, but the problem is he had a lot of felonies in his background, and that's, you know, he was a meth head and a meth dealer, and he had a lot of ugly stuff that comes in had he taken the stand. So, you know, we were trying to keep out a lot of that, even though we acknowledged to some degree that he had a bad past.
Why not still have him go up? I mean, even given his past, just give his accounts and
Right.
show the jury his side of the story.
Because Jennifer Nichols absolutely tore up 2 law enforcement officers that testify for a living, so I did not want to put Zach on the stand and have her cross-examine them. I just don't think, you know, he doesn't have a high school degree. Not that high school degrees mean everything, but, you know, he's not sophisticated. He's not had any experience with that. He's never had a trial before. All the times in the past, he's always pled guilty. He's never before even seen a jury trial. I just don't think that he would have been able to withstand stringent cross-examination, even if he's innocent.
Thank you, Jennifer.
Thank you.
Sure. It's been a tough day. Okay.
That was Zach Adams' defense attorney after the verdicts, but before this plea deal was announced on Saturday, where her client was able to avoid the death penalty. I started taking notes there, Caroline. I guess you did too. What's your reaction to listening to that?
I am kind of, I feel like I'm Julie Rendelman here because I'm kind of speechless because I hadn't seen that either, and I'm just like kind of in an alternate universe. I don't know any defense attorney that would get up and say the things that she's saying.
Yeah,
I mean,
right off the bat,
just the
Zach
whole thing.
Adams was high and he
Yeah.
was saying inappropriate stuff so.
He's a meth head. She said he's a drug dealer.
The tactic seems to be to blame the drugs on this stuff, and I don't know that should be coming out of her mouth at trial, let alone there.
She said so many things. She was talking about her, you know, attorney-client privilege communications between her and her client.
Privilege.
Like, I mean, she's saying she said I, you know, wasn't hopeful about the verdict. I mean, who says that? I mean, it's just. I'm still kind of just like reeling from, again, I just
it
don't know
almost sounds
what's
like
happening.
she just believes the state's case, and I mean, like, who is she defending? I mean, isn't it?
No, I mean,
I'm speechless too. Okay, I'm trying to string words together.
No, you mean in terms of the drug stuff? No, I think her point is that she's defending her decision not to put him on the stand, because the point she gave there was that. As we were talking earlier about, Aaron, you know, all of his priors would come in if he gets on the stand for impeachment evidence, and that wouldn't look good. I think the point about him being a meth head, and him, I think I wrote some notes here too, that he's a meth dealer. He had a lot of ugly stuff that would come in if he were to take the stand. And then I think the other part is she's blaming potentially some of that hearsay that got in, that made its way in about potentially Zach Adams sort of bragging about having committed the crime. I think she is blaming it on potentially the fact that he was high on meth, that he was lying about it. I don't know. I'm still confused.
Yeah, one thing that I have not read and that I would love to read are the motions in limine to determine what evidence was coming in and staying out before the case was tried.
Yeah,
I don't know if I'll get a chance to ever look at the full record, but I wonder
well,
if it was decided if it was decided that stuff was coming in, I guess she was going to have to figure out a way to deal with it.
Right, but I think specifically some of the things I wrote down that she said, like the whole issue with Shane Austin's suicide, she specifically stated she did not believe that should have come in. The fact that the state brought in the fact that he had an immunity agreement, she did not believe should have come in. And I agree, those had to have been motions in limine, so I would like to read those as well to see how the judge came out on that issue. But a lot of times motions in limine are decided very close to the beginning of a trial. She clearly wasn't prepared to deal with the evidence that she knew was going to be presented.
So one thing that stuck out in my mind is this whole notion that she said the jury misunderstood, those were her words, this whole tactic where she was trying to point the finger at this other person who was sort of a known sex offender in the area. And my reaction to hearing it was, well, if she said, well, we don't have the resources to prosecute someone, but that's the way her case felt to me.
Yeah.
She did say that, and then she said the jury misunderstood what we were trying to do. We weren't trying to prosecute the other person. We were trying to raise reasonable doubt. Well, if the jury misunderstood the tactic, it's because you were using the wrong words.
Exactly. She didn't, she both sort of overestimates and underestimates this jury sort of simultaneously. Overestimates in that I agree with you. I don't think she went through sort of the just reasonable doubt 101, the burden of proof on the state. I don't think she hammered that home enough, and I don't think she explained to them that, look, she's not trying to prosecute a case on her own here. She's not trying to lay out, sort of an airtight case against somebody else. All she needs to do is give enough of a reasonable doubt, and she should have told them that that's what she was doing. Otherwise, she ended up looking how she did end up looking, which was just all over the board and with no real clear tactic.
Yeah, I mean, this focus on this other potential suspect should have been rolled up around the bigger snowball of reasonable doubt. Hey, look, you got a bunch of jailhouse snitches. I mean, Ken Belkin and I did this argument back and forth just for practice here on LawNewz one day. Julie Rendelman and I did another version of it, and just getting into, hey, look, you've got people sitting on the witness stand admitting that they're liars, but they're trying to get you folks to believe that now all of a sudden they're telling the truth. Well, guess what? They might be lying to you now to get off the hook because they're accused along with this guy.
Exactly.
So can you believe them?
And she did not hammer, she did not go after those witnesses on cross. She did not sort of get every angle there. She really let them off easily, in my opinion. All of those jailhouse snitches, she could have gone further with sort of their propensity for truthfulness and the fact that they have lied in their past and that they aren't credible witnesses, but she really didn't hammer that home.
Yeah, one point that she did make is this whole notion about whether it was possible to get an unbiased jury in this area. And she filed a motion to move the case because the county where this crime happened is very small. A lot of people played roles in the volunteer search for Holly Bobo, and a lot of people had heard the whole story or most of the story from start to finish. Well, proper as a defense attorney to seek a change in venue, but then the venue is the next county over where people were still involved in some way, had heard a lot about it. I think that she does have a point there.
I think she absolutely has a point. We were talking about this off camera. I mean, look, when you make a motion to change venue, you don't make a motion into which venue you would like to go. You simply make one to change it, and then it's up to the discretion of the court system to figure out where it goes. So I can't fault her for this, but I agree. I don't think that whatever purpose in changing the venue was meant to accomplish, it did not do so merely moving it one county over, because there's no difference.
I mean, if you're trying a case in Kansas City and you want to change a venue, you get a jury from Columbia or St. Louis or something like that, not the next county down.
Right.
I mean, it's just, it defeats the purpose of the whole rule of asking for a change in venue.
Right.
But given what else wound up coming in, I think that the most unbiased jury in the world still would have convicted the way the trial was done.
Yeah, I agree with you. Again, I mean, I hadn't had much familiarity with this case prior to covering it on LawNewz, and I still felt a real strong inclination towards a guilty verdict here.
Well, let me ask this. If a different attorney had tried the case for the defense, would this defendant potentially have beaten at least some of the charges?
This case, I think it's more of it's an all or nothing type. Either he's guilty on all three or not guilty on all three. It's too hard to tell. I mean, in a world, in a, maybe you think if maybe Jose Baez had been in that courtroom defending Zach Adams.
Well, what about
maybe.
Caroline Polisi?
Yeah. Oh, well, certainly Caroline Polisi. I mean, that goes without saying. But potentially, I mean, I think that there were so many ways to even actually. I learned more about the case in her sort of in this. I think she didn't drill in. I didn't hear a lot of her tearing apart the sort of the cornfield. Her take on the cornfield it would have only taken 10 minutes. If you credit Jason Autry's theory, then the timeline doesn't exactly match up, and it's inconceivable that this crime could have taken place. I didn't see her hammer that home.
I don't think that she had a couple of brass rings she could have grabbed here, but she just let him go on by.
Yeah, she let them go.
And so, look, I mean, I don't think, as I've said before, I don't think this defendant is a sympathetic guy in the slightest.
No.
But I have to just sit here and wonder, okay, well, what's up with some of the evidence that came in that probably shouldn't have? What's up with some of the hearsay? What's up with the evidence fights in front of the jury?
Right,
and then there's this thing that happened that we heard over the weekend where the judge was dismissing the jury. I believe that's the point when it happened. I want to go to this and hear what you think about this, Caroline, because this is where the judge is sort of, he's had sort of a loose and somewhat jocular manner with the jury, but this is where the judge is on the bench talking about the members of the jury that he knew personally.
I don't blame you. I'm going to discharge you at this time. And here's some instructions. First of all, I told you I can't safeguard your name, but I also told you that I will protect you. If someone wishes to discuss the case with you, that's your option. If you don't want to, you're not required to. If someone persists in wanting to get you to discuss this case and you don't want to, you get word to the clerk's office or the sheriff, and I promise you I can take care of that, okay? When I discharge you, I want you to go to the jury room. You can take what you want from those notebooks. Anything you want to take from those notebooks, you may do so. If you've got personal notes, if you want to take those, fine. If you leave them in there, they'll go. This lady over here will run them through a shredder. If you want to take them with you to assure your privacy, you're free to do that. If you want to take portions of the charge or the charge, you can do that. You might have written on it or anything, just take it out of the notebook. I do reuse the notebooks. Matter of fact, how many sets we got? Okay, 5. I just wanted to keep 3 because sometimes I'll be trying cases back to back to back. Most cases I don't do 12 days like we have on this. This is the longest case in my history. Probably the most complex. And as I said, I can't commend you folks strongly enough. When you file out, go to the jury room. Then you get what you want to from that. Is Miss Peck in here? She's probably in the press room. She will come up there. If any of you want to give interviews to the press, you can do so if you want to. But she will probably give you some guidelines, not trying to limit what you say, but make sure you don't say anything that might embarrass other jurors or anything like that. If you don't wish to do that, that's fine. Your privacy will be protected. You might again be contacted in the future. I had another very high-profile case. The attorneys on both sides said I could disclose names, and those people were contacted by 2020 or one of the news programs. It might have been Dateline, I don't remember. And about half of them were willing to discuss. Some of them really didn't want to. They were respected in their decision. So everybody understand that? But go first to the jury room, and I think Ms. Peck will join you up there and probably be with you if you wish to lend yourself to an interview. And like I say, you might be contacted further down the road. That's up to you. In other words, if you want to talk, that's fine. If you don't, that's fine too. Do we have questions? I can't thank you folks enough from the bottom of my heart. This is above and beyond the call of civic duty. And I will tell you, if your name comes up on down the road, you just mentioned that you served on this case, and the clerk will excuse you on that one if you want to. Okay. You folks got any questions? I know a lot of your families. Your little boy played baseball with my youngest little boy. I've known your daddy for 1,000 years. And know you at the bank. I'll try not to come up to you, put you in a cold sweat if you see me before long. But I know a lot of you, but I really appreciate what you've done here. So if you would stand, the jury can.
So Caroline, that was some of the conversation that the judge had with the jurors upon dismissing them, and it sounded sort of like a conversation in a diner on a weekend morning.
It did. It did.
Did it concern you?
It did. I'm still in shock. It's just so different from what I am used to in New York. Things are much more formal. I don't think you'd ever hear a judge talk that way to the jury, really. I mean, even the idea that he said he thanked them from the bottom of his heart, I mean, that struck me as a little weird because it's taking it to a real personal level. I heard earlier today one of Heather's guests was a family friend of Holly Bobo's, and he talked about how they were praying in the courtroom with many of the bailiffs and really the people associated with the court. Also quite shocking. I mean, it's I guess it's just how things are done down there, but it is much different than here.
Well, I mean, I grew up in a smaller community upstate and served on a jury once, and I remember things being by the book.
Okay.
I mean, as a member of the jury, I was a little bit afraid of the judge.
Yeah.
You wanted to do the right thing. You wanted to do as good a job as you could. But I remember the judge saying things about, both parties appreciate that you've taken your jury service seriously.
Absolutely.
Something like that, because
civic
it's
duty.
an important thing. We know that you've taken time out of your lives to consider the dispute. Just remember that if you ever need the courts to settle a dispute, you would want a jury to give the case as good a consideration as you have, and something like that. But it didn't go much beyond that.
Right. Well, the idea that
it was still official.
Yes.
It was formal.
The idea that he's thanking them from the bottom of his heart implies that they did a favor to him personally, which is certainly not the case, nor should it be construed as the case. The bigger issue, obviously, were these sort of asides that he then gave about, my youngest played baseball with your youngest. I've known your daddy for 100 years.
1,000 years.
1,000. Sorry.
Like that, yeah.
That was
judge is older than I realized.
Right. Yes, exactly. That was even more off-putting. I think he may be able to get around it with the sort of small town culture and the idea that, look, I mean, in voir dire, for example, they always have the attorney stand up and sort of address the jury and look at the jury, and then the jury writes down whether or not they know the attorney personally. But I'm trying to think back on my previous voir dires. They don't do so. It's not that case with the judges. They don't ask the jury if they have a personal relationship with the judge, but they do ask, or anyone in this courtroom.
I've seen that question on
Yeah.
some of the forums that I've seen, though, just as a journalist. So,
Right.
you know, if you know the judge, you're off the case.
Right, but the question is, like, how specific do you need to know that person? And growing up, being from a small town, chances are you're going to know everybody there. So, you know, I think if this issue does get looked into, we're going to see more of a real getting to the bottom of the exact relationship between these people. It could just be sort of a familiar face type thing.
Yeah, I mean, I don't know. I mean, I've been trying to get a little bit acclimated with Tennessee law over the course of this, and it seems like every time I find an issue that would result in a huge issue in other states, including other small conservative states, people need to remember my first law license is in New Hampshire. It's not known for being a liberal state in the Northeast. That's Vermont and Massachusetts. You know, some of this stuff in New Hampshire, gosh, I think if a judge would just be white and aghast
Right.
up there, because they're very concerned about, you know, notions of fairness, and they also are a little bit more concerned than some other states in trying cases on their merits, especially with civil cases, rather than dismissing them on some procedural
Right.
thing. They tend to try more cases than not, but a lot of people don't try it, or don't complain, I should say, about that, because they say, well, you know, let's get it in front of a jury. But you know, I think it might be a bit of a misread to try to say, oh, well, that's the way things go in Tennessee, because I know plenty of other small communities that can have trials that don't leave me with some of these questions.
Yeah,
You know,
I'm just trying.
it's a constitutional right to have an impartial judge. There are rules of procedure that say you get an impartial prosecutor. Well, this prosecutor is up there on rebuttal talking about Holly Bobo's family as a we.
Right.
And I hear from people that, well, she's so close with them now that they're friends.
Right.
You know, you have a right to an impartial jury. That's a constitutional right as well. So
Yeah.
I wonder what the interpretation, if this is appealed on those grounds, we'll start to see, because, or is it one of these things where the appeals court might say, well, it's not enough of an issue. Yeah, you get a right to an impartial judge, but this isn't evidence of an impartial judge, because the seminal U.S. Supreme Court case that deals with that is one where a judge was involved with business dealings with an opposing party. It was more of an entanglement, but I guess the question up for debate is, how far does the entanglement need to go?
Yeah, and even besides the point of the actual entanglement, there is this sort of concept in the law. We say a lot about an appearance of impropriety. So even if there is sort of the mere appearance of an impropriety there, that can be enough to sort of really shake the public's trust in the system. So we, as a criminal justice system, we want to sort of move away from any appearance of impropriety, whether or not the actual underlying impropriety is there. So look, this may be enough to get there. I don't know. Who knows what the appellate court in Tennessee thinks about these issues. I think, you know, the question will be, a lot of times it's easy to sort of scoff away issues on appeal, saying, well, you know, it wouldn't have had an ultimate impact on the trial. Yes, this was a mistake, but you know, it wouldn't have changed.
We're seeing more and more of these things dismissed as harmless error.
Correct.
And some of the issues that I was starting to talk about, you know, the leading questions. I started reading into that in Tennessee. They usually just say, oh, well, whatever. I mean, well, if that's the case, no wonder we see prosecutors leading witnesses around, because if you did an objection for leading, would a judge smack down the prosecutor and say, knock it off? Or would the judge just let the prosecutor keep going with it?
In New York, they wouldn't. I mean, you know, but who knows in Tennessee? I mean, you know, I think there was a real feeling of solidarity among the prosecutors and the judge in this case. Look, you know, remember, we're also not talking about the fact that you know, there was a motion for him to recuse himself because he did state that he believed that defendants in this case should have taken a plea deal. Now, you know, I'm not saying that I haven't heard from judges in a global fashion, to me specifically, about, you know, you might want to think about taking a plea deal, but that's the context there is more like, look, nobody wants to take this case to trial. you know, it's not specific. It's not, I have reviewed the evidence and I feel like your client is guilty. It's more of a, you know, for the sake of, you know, judicial resources and for everybody's time and money here, why don't we try to work something out? Here, it seemed a little bit more like this judge was really veering into dangerous territory and sort of giving his 2 cents about the evidence in this case and about his feelings about the guilt or innocence of the defendant, which is not okay.
There are a lot of things that, you know, they're just kind of like towing up to the line.
Right, right.
And a lot of them, look, I mean, I'm more burned up at the way that the defense handled the thing.
Right.
If I were to say where I'm concerned, it's like, well,
yeah, what are your top five appealable issues?
Well, gosh, I actually did stop keeping track because after I hit like 10 of them, I just was, I just felt like I was trying to bottle Niagara Falls, and you just can't really do it. So, you know, we've got the leading questions, we've got the hearsay, we've got some of the stuff that came in against the defendant, prior bad acts. You know, now you've got this whole host of other issues, and that's just the way it is. But the Morris trial looks like it's coming back into session any second here. We want to go to that case. They've been on about an hour and a half lunch break. Good time for a lunch break in Phoenix, apparently. And